for inviting me. And as Neil said, the presentation will be relatively brief, try to provide a frame of what are the major copyright issues educators generally both need to understand and probably face daily, and then also how is that landscape changing, particularly with the emergence of public licensing models like Creative Commons. So you can go ahead and go to the next slide. Briefly, Creative Commons is a nonprofit based in San Francisco, but with global presence. It is not technically a law firm, so just as with Creative Commons itself, everything I say is not technically legal advice, but we do work in the legal domain, provide legal and technical tools that allow people to share their works on more flexible terms than would otherwise be possible. And at this point, it's becoming more and more widely accepted that the Internet is a global medium and sharing has become a globally mediated process, and Creative Commons is an important part of that infrastructure. The next slide. So digital technologies, we can all agree, have revolutionized the way creative works are made, distributed, and used. And at this point, for anyone to be working entirely outside the digital domain, if you're dealing in information, is pretty unusual. And so the question becomes, what's possible, right? What does this mean in terms of the rights you have and management of those rights? And if you go to the next slide, every day we use movies, pictures, text, music. In education, almost everything you touch can probably be digitized and deals in information in some way. And on the next slide, you'll see that copyright, which has a universal symbol, you see in the circle, covers everything you want to use. It's extremely difficult to find something that doesn't have some bearing on copyright, particularly in education. It also covers essentially everything you want to do. Copying, emailing, modifying, sharing with colleagues. All of those activities are, I guess, affected by or otherwise moderated by copyright, even if it's on the Internet or TV or radio. And therein a grand challenge. For many people, the Internet is different enough that it's not clear what rules don't apply. But in the eyes of the law, really global of something being on the Internet is irrelevant to whether or not copyright is still in force. And so if you go to the next slide, just as some examples, emailing that story to a friend or posting a picture to a blog or anywhere online, using a cartoon or a drawing in a handout, uploading resources that you might have found to some sort of web-based archive, copying or attributing significant portions of an article. These are all pretty standard activities, particularly in an educational setting, and indeed they all touch on copyright in some way. And on the next slide, the key issue that most people have with copyright is that copyright basically says all of these things are in fact illegal. So you can't do that stuff unless you get permission. Now, there's a significant caveat in education in that most countries grant special exceptions to copyright for educational use, and then some other countries grant additional exceptions beyond that, even if it's not in education, broadly considered fair use or fair dealing or the equivalent. Those exceptions are crucial, and they're really important, but they nonetheless are understood on a case-by-case basis, and it's very difficult for people to understand when they may or may not be falling within the bounds of the exceptions. And so the next slide just summarizes the feeling most people have about copyright. Copyright essentially tells people, don't do things, don't access things. If you do, you're a pirate. And as we know, there's significant pressure from major media companies and governments and others to sort of enforce what copyright says people are not supposed to be doing. And it's sort of set this tone of, yes, the Internet makes a lot of things possible, but unless you sort of pretend that you're still routing through a pre-Internet, pre-digital culture, and therefore get all the permissions and everything you need, you can't actually do most of the stuff the Internet makes possible. Hopefully everybody's still with me. The next slide.
Yeah, keep going, Aris. It's all great.
Excellent. Thanks, Neil. So on the next slide, this is really probably the key issue for most people today, is that Creative Commons, and really Creative Commons is the global standard for this, but you could say any global public license flips copyright on its head. It takes copyright, normally interpreted in this very negative, restrictive way, and it flips it over and says, actually, let's make copyright all about what's possible. Let's talk about the opportunities you can get courtesy of something like a public license. On the next slide, Creative Commons provides tools for creators to grant permission ahead of time for one or more activities. Those permissions include, on the next slide, the right to copy and distribute, to perform, to display, to build upon works, or to remix them, to mix different works together. These tools, next slide, are also for managing your own copyright. And it's really important that people understand that Creative Commons is an opt-in system, and it's a system that requires the person who owns the copyright to opt in. So although many people understand Creative Commons and all this as being kind of a philanthropically motivated exercise or something where people are thinking there's some greater good involved, all of which I agree with, nonetheless, a substantial fraction, maybe even half if you consider the media and music industries, use tools like Creative Commons to actively manage their own copyrights in their own self-interest. There's a number of benefits you can get from something like CC licensing, which, in fact, all rights reserved hampers, depending on your needs. So how does it work? There are, so I should point out, it essentially enables things so that you can collaborate and share material with anyone, and so then the question becomes, where is that interesting? Why would you want to do that, and how do you make it as easy as possible? So how does it work? There are 4 license conditions. Those license conditions briefly are attribution, so you can use the work but just tell people where you got it from. That's the man in the circle. The share alike, which is the left flowing arrow, that means feel free to use the work, but you must then re-release any derivatives you've made under exactly the same licensing conditions so that others can build on your work as well. The $sign, there's also a pound sign and a circle version. Basically, the non-commercial means feel free to use the work, just don't sell it or profit from it directly. And then the last one, the equal sign, means no derivative works. So share it freely with anyone, just don't change it. And if you mix and match these things, attribution is required on every single license. So it's really mixing and matching the remaining 3. You end up with, on the next slide, 6 different combinations of licenses, which are listed here. And I won't go into all the details about the differences among these. People can ask questions if you have specific questions. Crucially, CC consists of 3 key parts. All CC licenses have what we call a human-readable deed, and that's what most people encounter, and then a lawyer-readable code, and then a machine-readable code. And I'll go through each of those in turn. So the human-readable deed, which is shown here, is essentially the thing most people encounter when they're trying to understand what rights have been granted by someone who has used a Creative Commons license. And it distills the essence of what's been granted and what has not been granted down to a simple one-page deed. And so in this case, it says you're free to share the work freely and you're free to remix it. You just need to attribute the original author. And so it maintains that credit economy, which particularly in areas like education is so crucial, in that people using the work must actually indicate where they got it from. But otherwise, you're free to do whatever you need to with it. The next slide shows the lawyer-readable code. As you might expect, it's virtually uninterpretable unless you're a lawyer, and even then, it's questionable. But the reality is that lawyers of various stripes and very high quality have